Okay, good afternoon, everyone, and welcome to this webinar on applications under FPR Part 25, dealing with the instruction of experts in proceedings. Starting off first and foremost, what is an application under Part 25? This is where you make an application to instruct an expert or for expert evidence to be put before the court. This covers both children proceedings and also financial remedy proceedings. In the case of children proceedings, the application will also include, where necessary and appropriate, permission for the relevant child to be examined or to be assessed. The procedure applies to both applications for single joint experts and also experts who are instructed solely by one party. The reason that you have to make this application is because in both financial remedy proceedings and children proceedings, the permission of the court is required before you're able to put expert evidence before the court. Just as a point of clarification, and it probably goes without saying, but an expert is a person who provides expert evidence for the use in proceedings. The reason that they're treated slightly differently to other witnesses who might give evidence in proceedings is because an expert is allowed to advance an opinion on matters before the court, provided they have the necessary expertise in that area to be able to do so. You'll note on the very last point on this slide that in certain categories, witnesses in children proceedings, that there are certain categories of individuals who are not classified as witnesses when it comes to children proceedings. Those are, for example, social workers and a CAFCAS officer. The question for the court when it is considering an application for expert evidence to be adduced or for an expert report to be obtained is whether or not that expert evidence is necessary to assist the court to resolve proceedings. Re HL in 2013, the Court of Appeal gave guidance on what the meaning of necessary can be taken to mean. Really, it goes, and you'll see there, it's somewhere between indispensable on the one hand and useful or reasonable or desirable on the other hand. It falls in the middle of that. Really, it's to say that it's something that the court is going to need rather than something that would be desirable to have in the proceedings so that the court can determine the issues that are before it. When should an application be made? In almost all sets of proceedings, the answer is as soon as possible. FPR 25.6 sets out the earliest stages or the ideal stages when an application under Part 25 should be filed with the court and then therefore considered. You'll see there that in cases under Part 4 proceedings, so those are applications for or proceedings by way of an interim care order, care orders, supervision orders, secure accommodation orders, and although not strictly private public law proceedings involving special guardianship orders, so public law proceedings in that same vein. In those cases, the application needs to be made no later than a case management hearing. In private law children proceedings, so children proceedings for child arrangements orders, special guardianship orders, changes of name, or applications for parental responsibility or enforcement, the application needs to be made no later than the first hearing dispute resolution appointment. So that's the very first hearing in those proceedings. In adoption proceedings and placement proceedings, no later than the first directions hearing, and in proceedings for financial remedy, no later than the first appointment. And really what can be taken from this is the sooner the better. You'll see right at the outset that the court does have discretion to extend the time for when permission needs to be sought, and that's implicit in the provision that unless the court directs otherwise. So there is scope to make an application after those very initial hearings in the sets of proceedings that have been outlined, but the preferable position is to be able to make that application at that first hearing so that it can be dealt with at that first hearing and there's no consequential delays in the proceedings following on from the delays inherent in instructing an expert. In both financial remedy proceedings and children proceedings, there is a provision in the relevant practice directions under Part 25, Practice Direction 25C for children children proceeding applications and Practice Direction 25D in respect of financial remedy applications, for the court, for the application to be made as soon as it becomes apparent that it is necessary. So whilst the primary position and the ideal position is that the application is made at the very outset of the proceedings, it's not uncommon for the need for an expert to be instructed to arise at a much later stage in the proceedings, sometimes after all of the evidence has now been disclosed, or the parties have updated information they didn't have the benefit of having at the outset of the proceedings. In financial remedy proceedings, there is specific provision made for the court to give permission for an application to be made at a later stage, where there is a good reason for the parties to delay the decision as to whether or not to use expert evidence. Examples of that are, for example, until replies to questionnaire have been fully considered, because there may well be information that comes out of those replies that confirm the need for an expert to be instructed, for example, as to the valuation of businesses, business interests, or other financial considerations. And equally, property valuations, you may well find yourself in a situation where the parties are able to agree the valuation of a property or properties for the purposes of FDR, but if the case doesn't settle at FDR, then consideration needs to be given to instructing an expert to provide a valuation of the properties that are in dispute. Where an application is being made and it's not being made ahead of the very first hearing in the appropriate set of proceedings, there is provision and there is some scope in the rules to being able to make the application at a later stage. We've already looked at the ability for the court to extend the time by which permission needs to be applied for. In circumstances where you are applying for permission to instruct an expert outside or after the first hearing in respect of the proceedings that you are acting in, the ideal position is to make the application ahead of the next listed hearing or ahead of a hearing that has been listed in those proceedings. For example, at a directions hearing, if you know one has been listed, or a PTR or other relevant hearing, you make the application before that hearing so that the application can be considered at the hearing that is listed. There are, unfortunately, still circumstances where you turn up to court, there is a hearing, and it becomes apparent at that hearing, or perhaps even the night before that hearing, that there is the need to instruct an expert. And it means that it's not going to have been possible to prepare an application notice as required. You may not have all of the information that you are expected to provide to the court when making an application under Part 25. In circumstances where this happens, you need to provide the court and the parties with as much information as possible, as soon as possible, and then the application can be made orally at the hearing. You'll see at the very end that this is an exception to the rule, and it should be reserved for cases where there are genuinely circumstances that the need for the expert has only become apparent shortly before the hearing. When making an application, it needs to be made under the Part 18 procedure. In Children Act proceedings or in children proceedings, the application should be made using Form C2, and in financial remedy proceedings, the application should be made using Form D11. The application should ideally be served on all parties unless there is good reason not to serve it on them. For example, the degree of urgency for which the application is required, safeguarding concerns, or other similar circumstances. What must an application notice state? There are general provisions for what an application notice needs to state, and then there are more specific provisions for Children Act proceedings or children proceedings more generally, and then financial remedy proceedings. I'm going to work through each of those in turn. As an overall position, the application under Part 25 needs to explain or identify the field in which the expert evidence is required. If practicable, the name of the proposed expert. Normally, you may find yourself in a situation where there are 2 or 3 CVs that are being advanced for proposed experts, and the name of the expert is not yet known, but it is quite clear that an expert is going to need to be instructed. So that's why the provision is made for where practicable. The court understands that there may not always be a clearly identified expert at the time the application is being made. You'll need to outline the issues that the expert evidence is to relate to. That falls to the necessity test. It's so that the court can determine whether or not this expert is necessary and what issues the expert evidence is required to comment on. You'll need to consider whether the evidence could be obtained from a single joint expert or whether the parties are going to need to instruct their own individual experts. And then the matters set out in Practice Direction 25C, which, as I've said, relate to children proceedings, and Practice Direction 25D, which relate to financial remedy proceedings. As with all applications that you make, a draft order must be attached to the application. So looking at applications within children proceedings, the application itself needs to set out, and you'll see listed on the slide, the discipline, qualifications and expertise of the expert. This is normally evidenced by attaching their CV. Sometimes they'll have a summary of why, of the work that they've done and the areas that they're currently working in. And that helps to evidence that the experts that you are proposing have the necessary qualifications and expertise to be appointed as an expert for the issues that have been identified. The expert's availability to undertake the work, and that needs to be confirmed well in advance of instructing the expert. You may find, for example, that there are some experts who are very, very busy, but because of unexpected changes in their diary, they're able to fit in an application at very last notice, but it's only in a very limited time window. And it means that the court needs to be alert to that so that if there's any implications on the timetable, those can be considered. The timetable for the report, that needs to include information and consideration about when the documents are going to be provided to the expert, when the letter of instruction is going to be sent to the expert, and when the expert is able to complete and return their report. The responsibility for the instruction, there needs to be identification of a lead contact who is going to ensure that the letter of instruction documents and any questions to be attached to the letter of instruction are provided to that expert and are done so in a timely fashion. Whether the evidence can be obtained only by one party, so this is the question about single joint experts. Why the expert evidence proposed cannot properly be given by an officer of the service or the local authority in accordance with their respective statutory duties or any other party to the proceedings or an expert already instructed. And this is intended to deal with situations where the parties are seeking to instruct an expert, sometimes, for example, an independent social worker. And while arguably CAFCAS or individuals from the local authority would have the necessary expertise to be able to undertake, for example, a parenting assessment or an assessment or viability assessment of an SGO or a proposed SGO, there may be other reasons that that expert within the local authority or that individual within the local authority or CAFCAS are not able to undertake that application. For example, where there is perceived to be a conflict of interest or where there is perceived to be a degree of hostility within the proceedings, it may well be of a benefit to instruct an independent social worker. The likely cost of the report on an hourly basis or other charging basis, the ideal situation is to set out the likely cost of the report on an hourly basis, to state the hourly cost and then also confirm with the expert how many hours they anticipate they will need to be able to complete the report. The reason for doing this is because when the court is coming to consider the cost implications of the instruction of the expert and also whether the parties are going to be able to afford to pay for an apportionment of the cost of the report, or more generally whether or not there are going to be issues with any parties who are being supported by way of legal aid. For example, whether prior authority is going to be required, or whether or not the court is going to have to put a cap on the number of hours that the expert can incur or the cost of the report, and equally whether or not the court needs to consider a apportionment on a different standard or a different scale so that the cost can be covered adequately. And you'll see there the proposed apportionment of any jointly instructed expert's fee. As I said earlier, a draft order needs to be attached to any application. Where you're making an application in children proceedings, the draft order needs to set out the issues in the proceedings to which the expert evidence will relate, the questions that the expert is going to answer, and those questions need to be approved by the court. The party who is responsible for drafting the letter of instruction and providing the documents, the timetable, the disclosure of the report to the parties and any other party, and where relevant, there needs to set out information about the preparation for and conduct of any experts' discussions and the provision and agreement of statements of agreement or disagreement between the experts. The court will also need to consider, and this will need to be covered in the order, the attendance of the expert at court to give oral evidence. Sometimes they'll do so by video link, particularly if they're quite far away. It shouldn't automatically be presumed that the expert is going to be called to attend court to give evidence. And that's why at the very end, I've suggested that the order also needs to include provision for written questions to be asked of the expert by the parties. That's covered by FPR 2510. But you'll find that sometimes any disagreements or uncertainties arising from the expert report can be better and more efficiently dealt with by sending written questions to the expert under FPR 2510, rather than requiring the expert to attend court to give evidence to answer those questions. And certainly the court will expect the parties to have asked any questions before they give an indication that they expect that expert to be required, and therefore request permission from the court for the expert to be called to give evidence at the hearing. In financial remedy proceedings, you'll see that the application needs to cover very similar topics to that in children proceedings. For example, it needs to cover, again, the discipline, qualifications and expertise of the expert, ideally set out in their CV, the expert's ability to undertake the work, the timetable for the report, the responsibility for the instruction, again, whether it can be obtained by one party or the other, or is going to have to be obtained by parties separately, why the expert evidence proposed cannot properly be given by an expert who's already been instructed. For example, if you already have an individual who's providing valuations of properties, do you need a separate expert for each one of the properties, or could one expert suffice to provide valuations of all of the properties that are in dispute? The likely cost of the report, and then again proposed apportionment. Again, the order will need to set out the matters which you've already had to set out in your application. So the issues, the party who's responsible, the lead solicitor, a timetable, disclosure of the report, again, consideration for organisation of expert discussions and statements of agreement or disagreement, particularly where there's more than one expert that's been instructed. And then again, the attendance of the expert at court to give oral evidence. You'll see here, again, questions can be written to the expert, and I would suggest that provision is made in the order for written questions to be asked of the expert by the parties, so that the issue as to whether or not that expert really does actually need to come to court, and the costs incurred of that expert coming to court can be fully and properly considered. So coming on to costs. The costs of a single joint expert report will generally be apportioned equally amongst the parties. The court, however, does have the discretion to depart from this rule, and this becomes particularly relevant where, as I said earlier, a party is receiving legal aid. You'll find that there are caps on the amount that can be charged as an hourly rate, and also the number of hours that can be engaged by an expert in completing specific reports. Where the hourly rate and or the number of hours that the expert requires is going to exceed what is ordinarily permissible under the legal aid regulations, then prior authority is going to need to be obtained. The difficulty with this is getting prior authority is not always guaranteed, and it takes time to be able to write to the legal aid agency to request that prior authority. All of that can cause very significant delays, and the problem can possibly be remedied by the court apportioning the costs in relation to the expert report so that they're not equally shared amongst the parties, but are instead apportioned so that any apportionment falling on any parties who are legally aided falls to an apportionment which is appropriate and acceptable under the legal aid regulations. And equally, where there are parties who have very limited financial resources, it may well be the case that one party does not have the financial resources to be able to pay or contribute towards the cost of an expert report, even where it is a single joint expert report. In cases like that, the court may well wish to depart from the presumption or the general rule that the cost should be apportioned equally, and may wish to give an apportionment or apportion the costs that are more appropriate and in line with the party's financial resources. Within the court's powers is also the power to limit the cost to be paid to an expert. The court can put a cap on the overall cost that the parties will pay to the expert, which may lead the expert to being more cautious with the time that they spend in preparing the report, but it may also be that any costs incurred over and above those that have been approved by the court will need to be dealt with separately or separately considered by the expert. Parties are jointly and severally liable for the costs, so that needs to be borne in mind when the parties are considering the costs in relation to any instruction of an expert. I've set out on this slide more general considerations that aren't always necessarily covered by the rules or practice directions under Part 25. Wherever possible, I would advise that you include a draft letter of instruction and all of the questions that you intend to ask the expert or put to the expert as part of their instruction. It's required in any instruction for children proceedings that the court has oversight of the questions to be asked of the expert, but it's still good practice to do this in any event in any other proceedings. The reason for this is that it will save time and expense, because it may well be possible that with all of the parties at court and their barristers or other representatives at court, the letter of instruction can be agreed at court, as can the questions to be asked to the expert. Where there are significant disagreements about the questions to be asked of the expert, those could be put to the judge on the day and dealt with there and then, rather than the parties engaging in lengthy correspondence trying to agree the draft letter of instruction and any questions to go to the expert. Before you instruct an expert, it's always worth confirming with any proposed expert the date that the expert needs to receive any papers and any letter of instruction by. Any dates to avoid. This is particularly relevant where the expert may be required to attend the final hearing or another hearing to give evidence. I've already touched on the fact that the court will not automatically direct an expert to attend court unless the court believes that it's necessary to do so in the interest of justice. It's quite a high test, and that's the reason why I've suggested that any order for the instruction of an expert under Part 25 should also include provision for the parties to ask questions of the expert, so that hopefully the need for the expert to attend can be avoided. In any event, it's worth considering whether or not that expert takes time off. Some experts will take 2 or 3 months off every year, and it means that if your final hearing or the hearing where the expert is likely to be required to attend is going to fall within that period, then that expert may not be the appropriate expert to instruct in the proceedings in which you're involved. I've said already the hourly rate for the completion of work and the hours that they require to complete it. This is much preferable to having a kind of fixed fee arrangement where it states the fee, particularly where there are parties who are legally aided. Ensure that the proposed expert is appropriate to the issues and that they have the relevant experience and remain active in the area of work for which the issues cover. It may be the case that an expert has previously conducted assessments on vulnerable individuals, or, for example, have expertise in assessing particular types of property, but they may well have moved their practice on. It may be a number of years since they last worked in that particular area in which you're seeking to instruct them. If their CV doesn't set out and make it clear that they continue to work in that particular area of where the issues are falling, and that they have the relevant experience. For example, some experts may have touched on a particular area, but it may not be clear that they deal with the specific issue that you're looking at. It's worth sending an email to the expert or making contact with the expert before you consider instructing them, so that you can confirm the position. I've certainly seen it where we have asked similar questions of an expert that we were considering, and it became apparent that the expert didn't feel that they had the necessary expertise to be able to complete the specific report that we were asking for. So it was a good thing in that case that we had confirmed with the expert first whether or not they were still practicing in that area and whether they felt that they would be able to fully and properly prepare a report based on the issues that had been identified. Particularly in children proceedings, and may also be relevant in financial remedy proceedings, is to consider what documents the expert is likely to need. This is best considered before the court gives approval or permission for the expert to be instructed, because it means that you can have the documents ready to go. It also means the other parties can have had input into the documents that are required to be sent to the expert. For example, an expert who's providing a property valuation does not need to have access to all of the parties' formies and any of the other disclosure within the proceedings. So it's not appropriate to send them an entire bundle of documents relating to the financial remedy proceedings. They may only need very limited information. The same can be said, for example, of a psychologist who has been instructed in other proceedings. Lastly, where in children proceedings, the permission of the court is required for a child to be assessed or to be seen by an expert, if the court gives permission for a particular expert to be instructed, do make sure that the order sets out that that permission has been given from the court for the child to be assessed and or examined by the expert. So that concludes a rather whistle-stop tour of Part 25 applications. I'll open up the floor to any questions if anybody has any. And I would suggest using the Q&A function if you can, or alternatively putting it into the comment box. Okay, there doesn't look like there's any questions coming in. If you do think of anything after today, feel free to send an email to either one of my clerks and they'll be able to pass it on so that I can have a look at it. The slides from today's webinar and a recording of the webinar will go up onto the Goldsmith Chambers website. You'll receive an email once it's been uploaded to give you information about how to access both of those. So thank you very much for joining this afternoon, particularly on such a lovely sunny afternoon. I hope that you have a lovely weekend, and I'm sure we'll be seeing you for other webinars again soon.